I've got 3 different topics, well, 2 really technically, and I've got 57 slides, so I've got 15 minutes. You're not going to see all of them for very long. First off, I want to make this disclaimer, in the words of Dr. McCoy. Damn it, Jim, I'm a librarian, not a lawyer. So when we talk about copyright, I'm going to give you my best understanding as a practitioner, but not as a lawyer. So if you have a really thorny issue, we do have legal counsel on campus, so I would defer you to that. But I'll give you what I understand. Copyright's in the Constitution, so it's important. All of our rights of copyright come from that. Its purpose is to do this: encourage advances in science and the arts, to create and disseminate knowledge. So these are things we're familiar with. This is the thing that most people don't get. My students, 90% of them miss this point, that benefits the author is a means to the ends, not the ends in itself. Content creators will say copyright is the end in itself. When they use terms like intellectual property, that's what they mean. That's not what copyright is. Copyright is a means to the end. And the end is those things we just saw: advancing science and technology and dissemination of knowledge. Congress is given the right to grant rights to copyright for a limited time. Currently, most materials prior to 1923 are out of copyright. Most materials after 1923 are under copyright. So for my students, that means their grandparents or their great-grandparents weren't born yet when copyright began for the materials they're using today. So I'll let you do the semantics of whether that's a limited time or not. I'm going to stay up on my soapbox as much as possible this morning. Copyright is not an intrinsic right. What that basically means is intrinsic rights are the right to life, liberty, and the pursuit of happiness. Copyright's not one of those because we can give it up. I can't sign a contract and give up my life. In fact, it's illegal for me to kill myself, right? But I can sign a contract that gets rid of my copyrights or gives up my rights under the copyright law. We do that every time we sign up for an iTunes account. All of you have read your contract. Every contract you ever signed for all these social media sites you signed up this morning, you've all read those contracts, right? But we give up certain rights. We can't do that if it was an intrinsic right. So just keep that in mind. Okay, so it's copyright to do these things: to make copies, to sell or distribute copies, to prepare new works, derivative works, or to perform a work in public. So that's what copyright is. Again, you can go through these slides. They're actually on the NECA site now if you wanted to follow along. And the notes are there. The notes I'm reading from are in there as well. So what can be copyrighted? I used to have a really long description of what can be copyrighted, and finally I just said this: everything. Okay? That's pretty much it. For all intents and purposes, again, everything after 1923 is copyrighted. So for all intents and purposes, unless we're dealing with history, and many of you are, unless we're dealing with history prior to 1923, the materials we're dealing with are under copyright. So just go into it with that assumption, and you're usually pretty safe. Technically, though, copyrighted materials are things that are in a tangible, original expression. So they're in a tangible format, and that extends to digital as well. It's something that can be perceived, right? It's got fixation and originality, so it has to be original content. A string of numbers is not generally considered copyrightable unless that string of numbers is creative or original in some way. That's why databases usually can't be copyrighted. Okay, what can't be? These are things that can't be. That's an interesting bullet list there. Public domain documents, things that are created or are outside of the copyright date. Ideas, facts, words, names, slogans. Those have other protections. There are other parts of the law, trademark in particular, but we're not talking about trademark today. Government works, at least in the U.S., materials that are created by the government or government employees in the course of their duties. So a government employee who writes a great novel doesn't give up his rights to that just because he's a government employee. The same is true for you all as university employees. Okay, some exemptions. The one we're going to talk about is the third one there, face-to-face teaching, and another one, not face-to-face teaching, using an extension of copyright called the Teach Act. But essentially, libraries have special rights that we can do, Section 108. We love Section 108. First sale means when you buy something, you can do with it what you want with it. And fair use is what our students get confused with. We'll talk about that in just a second. Okay. Fair use. These are some terms of what fair use is. Again, I'll scroll through this real quickly so that we can get on to the other stuff. Fair uses are these exemptions that we give by giving up the right to do whatever we want with anything we find on the internet or in print. as a society, we give up the right to just do whatever we want in exchange for fair use, right? So it's a social contract. We're allowed to use it under certain conditions, and we give protection to authors for other uses. This is what I've observed over the past couple of semesters with my students. They get the idea of plagiarism and copyright confused when they are confronted with both of them at the same time, as they are in my class. So they believe it's okay to apply plagiarism rules to copyright cases or copyright issues. What's a plagiarism rule? What are you doing if you're, one of the things we do with plagiarism, we ask them to define it. What is the biggest tip-off that you plagiarize something? Someone else's work and we don't get credit, right? So you have to do certain things, you have to cite it, you have to quote it, you have to do all other things to indicate that it's not your work, right? So they say, well, as long as I give credit to this copyrighted work, I can use it however I want. They confuse plagiarism with copyright. Obviously, copyright is not that. So I do a little bit of talking about that when I talk about that. But I get that all the time. I get as a justification for things they've used in a class, that's their justification. Well, I gave credit to the person, look at the end of the document. So they haven't plagiarized, but they could have violated copyright. A fair use, this is the reason that they would rather just say I gave credit. Because this is what the courts have generally held is the test that you have to give, a four-factor test that you need to give when you're trying, or you need to evaluate when you're trying to evaluate the use of a material, whether it's copyright or fair use or not. You want as many of these things in this top column to be applicable to your use as possible, and as few of these as possible. So you want it to be that it's either nonprofit, educational, personal, teaching, criticism, news reporting. The nature of the work is factual that you're trying to use. It's a published work that's factual as opposed to creative. So Harry Potter is less likely to be a fair use than a documentary on seals, I guess. How much the work will be used? If you're using a small amount, you're safer than if you're using a large amount, or the heart of the work. I use this example all the time about the use of Harry Potter. If you watch the last paragraph of the last book of all the Harry Potters, that's the heart of that work. So divulging that on a blog or something like that is probably violating fair use. The other one is this one I get a lot as well. The effect of the market. Most students say, well, I'm not selling it, so it must be okay. That's not the case. Whether it affects, and we also have some questions from faculty about textbooks. I'm making my students buy a copy so I can put the chapters online. So it's easier for them. That's generally not the case because many students won't buy the book if they know it's going to be online. So we use these we want as much at the top level as we can, and even then it's just kind of a guess. Well, I've got a lot of these factors. I've got more factors on the top level than I do on the bottom, so I'm okay. But it's still a guess. So when you're dealing, that's fair use in a classroom setting, right? When you're dealing with building materials, and then it gets more complicated. If you're in a discipline, your discipline has said, hey, we've got to get some of the ambiguity out of the copyright law, so let's write some best practices. Here's just a few of them, a stack that we have in the library. One for libraries, Code of Best Practices for poetry, open courseware, Visual Resource Association has one, the best practice for media publishers, scholarly research and communication, and different areas. You may find one of those of your disciplines. And they're just basically saying, well, we don't really know what the answers are, but here's our best guess at some best advice. And there are more. This is what I was referring to before, social media and copyright. All of you are hoping to, or I hope will be using social media to distribute materials to your students, to have them distribute materials back to you. It'd be good for us to maybe take a look at some of the agreements that we talk about. So let's talk about Twitter. All of us have read this when we signed up for Twitter. Glenn, you read yours, didn't you?
Of course.
Okay. And analyze it, send it to your lawyer, had them give a reply back. Yeah, so what Twitter's saying here is what they're going to do with your content. So they're saying if you want to use our service, that's wonderful. And they're not taking your copyright, but they're taking certain rights away. Remember, when you sign a contract, you give up some of your rights to copyright. Or you can give up some of your rights. And that's perfectly legitimate. And most of this, these are, when we read these, people get up in arms so they misread some of the legal terminology. You agree that it's the right for Twitter to make your content available? Okay, that's why I signed up, so that makes sense. To other companies, wait a second, I'm not sure I agree with that, but let's read on. Organizations or individuals who partner with Twitter for the syndication, so those tools that we talked about how you add your Twitter feed to Nika or add it to some other social media site, that's how they get away with it, because your content is, you don't determine whether your Twitter content can go to the front page of the New York Times or only a reader. Twitter determines whether your Twitter content can go there or not, because you've given them the right to do that. Broadcast distribution or publication of content on other media and services subject to our terms and conditions for such content use. One of the great straw men on this is, well, what if Twitter wants to build or publish a book of the weirdest sounding tweets on Twitter? Or how about this? They want to give it to the Library of Congress to archive. That one actually happened. Glenn commented on that earlier. Library of Congress is archiving those tweets. They have an agreement with Twitter that they're going to put it in some other medium. So your tweet is not yours to completely remove because now the Library of Congress has it. So there's Twitter. Just use two examples in my class. I use Twitter and I use Pinterest. Pinterest, because they're the ones that get the most controversy. Pinterest in particular, if you're a photographer, do you use Pinterest? Commercial photographer. Most likely not, because commercial photographers didn't like the terms of the agreements. Most of them. Same as, first of all, Pinterest is a great company because they immediately throw you under the bus. If you violate copyright, you've agreed in the contract that you are completely liable for copyright infringement, and they have no obligation to whatsoever to deal with that liability. So, because they say this is their nice version, right? You agree that any user content that you post to the service does not and will not violate any law or infringe the rights of any third party, including without limitation any intellectual property rights, publicity rights, or rights of privacy. So, read that how you will. I read it as Pinterest says, good luck, you're on your own. And don't forget to read the ads on your way out. Okay, subject, and this is the rest of the part, another part of their agreement. Again, this is kind of the Twitter kind of style of clause we just looked at. You grant us a non-exclusive, royalty-free, transferable, sub-licensable, worldwide license to use, display, reproduce, repin, modify, rearrange, and distribute user content on Pinterest for the purpose of operating and providing the service. This one's not so bad. The sub-licensable part is the one that photographers got upset about, because they didn't think it was right for Pinterest to sub-license their work outside of Pinterest. But this kind of a clause is usual on a social media site because they can't share your content on your behalf without your permission. So, all right, I used this last year. If you're not part of the solution, you're part of the precipitate. Chemistry joke, sorry. This shirt's on North Tees, maybe, I think, I'm not sure. But the picture of it, the picture of the person wearing it was on Flickr. So there we go. And it was Creative Commons licensed. This is where we get around, if you're worried about all this copyright, how am I going to determine whether something's copyrighted or not, or whether I can use it? Seek out Creative Commons content, or create your own Creative Commons content. Creative Commons, again, is a way for you and other authors like you and creators to create content and further refine the rights that they want to grant to people. Yes?
This will be my only interruption, I promise, but we had a lot of people yesterday asking or implying that they could go to Google Images and take pictures from there, and you cannot do that. That is copying someone else's picture, but if you do a search through Flickr for Creative Commons licensed images, that is a way you can find images that you can use on your presentations and other nonprofit settings. And so there are search tools that help you do that within Flickr. So you can just type in a word, click the Creative Commons box, and then you'll get a list of pictures that you can legally use.
Yes, absolutely. And I encourage you, all the images that you've seen on this, that's why these tend to be a little bit more plain vanilla, because it's a lot more searching to do. All the images I use in presentations for my class are Creative Commons licensed. Right? And I make that point to the students too, so that as a reinforcement that here, your instructor's using it too, is doing this kind of practice. But absolutely, Creative Commons licenses are ways that people who are, I'm going to say they're enlightened, how about that, want to allow other people to reuse and remix their content, or at least use it, you know. And these are the licenses, the combinations. Rather than looking at that, this is on the range of just say I did it, all the way down to you can't do a whole lot with it other than view it. The bottom one here is you have to say I did it, you can't be a commercial entity using it, and you can't make any derivatives, right? This one up here is you can do anything you want with it as long as you say I was the one who created the original. And then in between, these are the four, there we go. The four characteristics that you can grant to other people when you create your work or search for work that's been granted these criteria. Attribution, share alike, non-commercial, and no derivatives. I love the share alike because then that's viral. What that basically means is someone uses my content in a derivative work, they're bound, if I add the share alike feature to that, they are bound to relicense their work under that same license. So if you want to be an evangelist for Creative Commons and open access, license your stuff under a share alike license. That way, anyone who wants to use your stuff also has to do that. So coercion at the point of the sword, basically. So these all can be combined in different ways. I was a business major, so I don't have as much of a problem omitting the non-commercial on that. I don't mind if people use it for commercial purposes. You may choose differently on that. Yes?
It's about time if you want to open it up for questions.
Okay.
On this topic.
Oh, okay. This is the last part. Go to creativecommons.org, and you can not only you can go to Flickr and search there, use their interface to search for Creative Commons content, but creativecommons.org maintains a meta searcher that allows you to search a whole bunch of different media.
It's on the Nika site.
And it's on the Nika site, and it's in the PowerPoint presentation too. So you can learn about the licenses and create one. There's a widget for you to just bullet point. It creates a human readable license and a legal readable license, implying that lawyers are different kinds of human beings than us, I suppose. But it gives you a long boilerplate, and then it also allows you to donate if you really want to, and buy swag and stuff like that. Okay, questions about the copyright. Again, copyright I have a 2.5-hour class on Wednesday nights, and I talk about copyright that entire class. So they hate me at the end, but that's why I do the evaluations 6 months or 6 weeks later. Any questions about copyright that you're concerned about? Yes.
Somebody told me that the law requires that you make a good faith effort to find out about the copyright status or something. That after you make a good faith effort, you can't find out anything, then you can use that.
That would probably lean towards that four-factor test, where if you can't determine what the economic impact, that's where it would fall in as far as I'm concerned. If I can't find out who would benefit from the sale of this item, then I can make probably a good case that I'm not impacting the commercial. There's a whole lot of legislation happening about what we call orphan works, things that no one knows the copyright, and there may not have ever been any assertion of copyright at some
I
point.
went to Oxford University Press once, and they sent me back a couple letters that were kind of mumbo jumbo, and didn't really say anything.
Yeah.
And they were just obviously trying to not say anything.
Yes.
So I figured, well, I made my good faith effort.
I teach this to my classes as well, is where look at the bias whenever you get an answer from anybody. Look at where, I said to my wife all the time, I'm shouting at the TV in the morning, follow the money, right? And for example, we use a lot of times the Copyright Clearance Center. Well, they will tell you that you have to copyright everything. Fair use doesn't exist. Other people will tell you that fair use is everything and you can use anything. So you have to make that four-factor test.
Which one are you saying?
I'm saying make a four-factor test. We're all copyright consumers and creators, right? We all create creative people. So, and if I ask a faculty member 2 questions at 2 different times, right? One, should I be allowed to use any copyrighted material I want? Absolutely, yes, that's great. Can I use your article or your textbook that you wrote? And then the answer is different 2 hours later, right? Because we have different we have different needs at different points, right? Yeah.
My understanding is that you take a photograph, you own that photograph, even if I'm taking it of your house.
Yes. In the U.S. In Europe, it's different.
Now I'm in class, I take photographs of my students. Do I have to get their permission for every photograph?
You're wandering into my talk.
Yes.
So there are FERPA issues. So as long as the student has consented to allow you to publish the photograph of them, there's no additional consent that's required. Miami has a policy basically stating if a picture is taken of you doing a Miami thing, whatever that is, that we're going to use it for publicity purposes. And we don't.
What if I just use it to identify the students for my own use?
So we would push you to the photo roster, requires no additional.
Which is when they came in as a freshman, and some of them have afros, and they don't look that way anymore.
He's saying that, so there's the possibility that your data is going to get out at some point?
No?
Yes. I mean, that's just the nature of computer security, right? If you have put the data somewhere, there is a chance the data will get out. So you would be safer in getting that student to consent to what you're doing. Because you're taking that picture only because they're in your class, so it is an educational record maintained by an institution, so it would be covered under FERPA, regardless of how you're planning on using it. If there's a chance this is going to be published, my argument would be to do that. Now, I'm also not a lawyer. Robin Parker may say something very different, but,
So it's on my thumb drive, it's not on my hard drive.
okay, have you ever lost a thumb drive?
No?
Continue that.
So, I know this is a little divergent, but let's say you're on a Miami project and the University Communication Office wants to use a picture of your students doing something really cool overseas. But you don't mention the student's name. You're saying you do not need their permission. Is that what you're saying?
I'm saying that, documentation communications is probably the simpler version of this. But I would say if that picture is taken during a class, there is a FERPA obligation. If that picture is taken during a spring break alternative break trip, that does not require it, because that's not an institutional thing, that's a student organization.
But doesn't FERPA have, like, beyond a certain age, it doesn't apply? Like, after the students are a certain age, it doesn't matter?
After the students aren't students, I mean, but there's not an age piece in there. The only age part of FERPA is I have a right to protect my educational records so long as I am of majority age. So once I'm 18 or older, my parents can no longer get my records. And actually, there are arguments you can make for high school students, or the opposite side of that sometimes successfully. But that's the only value of age in FERPA. Once you become 18, your parents no longer have a right to your educational records.
So there are a lot of departmental websites in this university where they're posting students.
If it was during class, my recommendation is to get a FERPA release. Now,
Where do you get those from?
Office of General Counsel's website. But the other side of this, there is only one penalty for FERPA, and it is basically never used. Right? If the Department of Education finds us in violation of FERPA, they remove all federal funding and proceeds. Right. It never happens. So what will happen, so this, whatever it is we're discussing happens, somebody complains about it, Department of Education sends us a strongly worded letter. We write a very apologetic letter about how it's never going to happen again, and that's it. So everything I'm talking about, FERPA, at the end of the day, it really doesn't matter. Yes.
Thank you, sorry for the.
I actually have FERPA slides coming, so.
Yeah, we can cover that in a minute. Copyright question?
Yeah, I'll go back to that.
Okay.
So, for example, I just read the use of content description on the Disney site because I plan to use a lot of that content over and over and over again when I teach this class. Like, refer to this attraction. What did they say will happen? And did it actually happen when you experienced it? So that's kind of how they'll do their audit. It said something like that you can only use it in association with the site itself. So as long as I'm like clicking the link or embedding the link of the whole site and not like trying to cut and paste, is that?
You have to, I'd have to, without looking at the contract, I would be sure,
Are
but
you allowed to just use anybody's links as a website?
there have been some court cases about whether I can link to something that already exists, and
Right.
I look at it this way. A link is the equivalent of a bibliographic citation. It's a way of accessing something. So what has been the biggest concern is deep linking. You link into the middle of a site and you bypass all of their advertising. So, and that's where the losses come in,
Yeah.
primarily.
Okay.
But I think in general, unless, it's better to use content in the spirit in which it was shared than not. But then there's a fair use component as well, which we'll talk about in just a second.
Okay.
The Teach Act. Prior to the Teach Act coming out, was being passed, 2002, I think. The only way you could use distance content in a course was through a very restrictive section of the copyright code called Section 112, which allowed you essentially, it covered video, and it allowed you to stream video from one recognizable classroom to another recognizable classroom. So it was the ability to have a classroom in Middletown and here, and we'd have a video camera connecting the two classrooms. But it was delivered primarily in a classroom environment. How many of you are going to be setting up a teleconferencing classroom for your class? Okay, besides Steve and Mary Jane. Okay, you're all both exempted. But most of us are not going to use our business classes. We're not going to use a big multimedia classroom. So the law was changed in 2002 to allow you to do a lot more. And primarily people were doing a lot more than just streaming video too. They wanted to use other kinds of media. All the stuff we're talking about today, we're not talking about streaming lectures back and forth from classroom to classroom. So the Teach Act gives us this. It improves, actually section 112, not 110. Redefines the terms of fair use, allows more works, expansion of receiving locations outside of classes. So and now the receiving location could be my student's apartment, or their cell phone in the middle in an internet cafe or wherever. It allows us to store some things, allows us to digitize some analog materials, include those as well. On that little bit. It has some requirements though. The government give and the government taketh away, right? We have institutional requirements, technological requirements, and instructional requirements. So all three of those groups are present here today. So if you find something I said wrong, correct me as we go. Institutional requirements look like this. We have to be an accredited nonprofit institution. Sorry, Coursera, you can't use it. We're nonprofit, so we've talked a little bit about accessibility, how they kind of have an advantage because they don't have to abide by the same rules as we do. At least that was my conversation yesterday. But now this is an advantage we have because we're a nonprofit accredited institution. We can use the Teach Act. We have to have an established copyright policy at the institution. We have to disseminate copyright information to our faculty and students. We have to provide a notice to students that the material on our course sites may be subject to copyright restrictions. And we also, of course, have to limit it to enrolled students. We can't invite guests. We can't open it to the public. And we have to do more than just put it behind a password. Usually what the institutional requirement actually comes later in the technological requirements. We do need to identify the exact student who's accessing the content and that they are officially enrolled in the course. Okay. Technological, this is where IT services comes in and builds an infrastructure that supports these functions. Has to be limited to enrolled students. Nika does a good job of that, doesn't it? Controls on dissemination. That basically means that once a student downloads something from a Nika site, that they can't just turn around and redistribute it easily. So that could mean we use streaming video or we use other kinds of controls. We are not allowed to modify, under the Teach Act anyway, we're not allowed to modify any DRM. So if any of you are using DVDs anymore, or even know what those are anymore, you can't remove the encryption and put it on a streaming site by ripping that out. There are other things we can use that, but technically if there's a DRM embedded in the product that we're trying to share, we can't modify that to make it work. We have to leave the DRM in there. We have to put in some kind of terms and policies for limited temporary storage. That's the kind of storage that's there while students are accessing it. And long-term storage, that's the idea that needs to be secure between classes. So if we want to use the same content this semester and 2 semesters from now, we're allowed to store it, but we have to secure it and keep it out from the open.
John, when you say DRM, I didn't...
Oh, I'm sorry, digital rights management. That's software and code that content creators put on their media files or digital files that restricts copying. iTunes iTunes Music is the big example there, but that kind of thing. Yeah,
Well,
Steve.
for a DVD, there's various programs that you can use to download that.
Yeah.
That's illegal?
The Motion Picture Association is genius in what they did in this when they created the DVD format. What they did is they created a brain-dead, stupid encryption system that literally a 10-year-old boy could break. He did actually. A 10-year-old boy broke it, and then distributed the software. But because it was so easy to break, it didn't have to be an effective encryption. It just had to be there. And then it fell under another law called the Digital Millennium Copyright Act that prohibited the decryption of encoded stuff. The reality is, yeah, there's lots of stuff out there. I think Glenn used the term, the toothpaste is out of the tube. Once the code to break that encryption was out there, there was no stopping it, even though they tried.
It's become a very interesting copyright discussion.
Yeah.
Because it was things like publishing the code was illegal, but publishing my photograph of the code was legal.
Right.
It was very bizarre.
So my question is, if I take a DVD and make a streaming video of it and distribute it to my students or have them look at it on a locked website, is that fair use?
it would, under the Teach Act, it would not be. Under the Teach Act, it wouldn't be permittable. Depending on, again, you could use it under fair use, but you're violating technically your, okay. I'm not a lawyer, remember. But technically you'd be defeating an encryption method. So technically that is illegal under the Digital Millennium Copyright
That's
Act.
why we're not doing it.
That's why we're not doing it at all, no. That's why we're buying our media without it, without DVDs anymore. Blu-ray's even worse, but Blu-ray's not having the kind of uptake I think people want it to be. So technological means, and this is IT services.
I'm just confused, we have a video on demand system, I know we digitize a lot of things for exactly that, so I don't know what's going on there.
I'm not sure exactly either. When I first heard about that, I thought that can't be legal. But someone,
We have a possibly very illegal service over in IT services you're not going to talk to us about, because.
and we're complicit here in the library. We keep a station here that does that too. So it's one of those. What we did there is we looked at to our vendors and said, "Can you be compliant?" And they said, "Why, yes, of course we can be compliant." So I guess it depends on who gets the liability. But I'm waiting for Gail to start throwing things at me. So let's go on. Instructional responsibility. You need to know what works are allowed. The nice thing under Teach is that it allows you to do a lot more works. Non-dramatic, literary works, musical works, anything else that's non-dramatic. Any other uses can be, as long as you're using a similar amount to what you would normally use in a face-to-face instruction session. So if you would not show all 3 Harry Potter movies in an instructional session, you would be unlikely to be allowed to do that under Teach Act either, to stream that. Unlikely. But anyway, commercial education products, a nod to the lobby for commercial courseware. If it's meant for distance teaching, you can't use it without a license. That's kind of a no-brainer, right? That would be in the law. There has to be instructor oversight, so I'm guessing that means you can't have this be an independent study, right? Unless there's instructor oversight. But the instructor has to be involved in the planning and distribution and dissemination of the course. That's kind of an easy one for us to make sure. And it has to be integral to the instruction. We get this all the time in K-12. Teachers who want to play a commercial video at a recess or at a break time that's not integral to the instruction, they have to pay licensing fees for that, unless it's part of instruction. Let me get that here too. Okay, digitization. Again, we can only do the amount that's appropriate to the instruction. So digitize a page or so out of an old book or something like that, but not the entire book unless it's there. And digital version isn't already available. If you can't buy it on the open market for a reasonable price, then you can digitize the analog material. Okay, breathe. That's a cue for me to breathe. How much time do I have? Negative 10 minutes, right?
Yes.
1 minute.
Yeah.
1 minute, okay. 25 more slides. Okay, I want to talk about digital scholarship real quickly. Digital scholarship is just a way that you can, in addition to just talking to your students about the topics and doing the instructional materials in the class, you can involve them in your scholarship as well. The nice thing about digital scholarship is that it can be on the net. And so students can participate to a level that they couldn't be when they had to come to your lab, for example. So I'm going to give you a couple of examples. This example, by the way, is a artist rendition of Vannevar Bush's Memex. Anyone ever heard of that? He wrote that in 1949, an article called As We May Think, where he visualized a device that all of our scholarship, all of the contents of the world would be on microfilm, and you could use them through a workstation like this. So it looks not bad for 1949, pretty close to the Memexes we have now, right? So digital scholarship. This is the definition from the American Council of Learned Societies, so it's not simple, but you can look at it later. Building, researching, creating, using, and creating authoring tools. That's what they see as the aspects of digital scholarship. So the things that enhance your teaching by practice, by doing things. This is an example of Artis Incunabula. That's a guy doing non-digital scholarship around a long time ago. We'll scroll past that. 2 metaphors of books, one chained and another one chained by DRM, but that's another thing. Transforming our scholarship, we'll skip that. I like that meme, but I'm not going to go into it. Here's an example of using online tools to allow students to help you out. Here's one. This is a Google map using an overlay with data that's being added. So students could conceivably add data as they find it. This is interviews project at the OSU called the Digital Archive of Literary Narratives, where they basically do interviews with people, and they go in and then they tag places that those people talk about and places where they are, and they just put them on Google Maps so that you can see the distribution of the ideas as they flow. This is a Google map of Civil War sites, right? So you could have students who then can add content to that using Google tools. Okay, some example of time. They can use data online that they can find. This is Landsat data. It's freely available. Yes, Peter? Okay, I'm out of time. Let me just show you this last one, and then I'll let you go. Just one more, Peter.
What I'm learning is never go after you.
Never go after me. No, it's a bad idea. This is an example of students that can take materials, and this is a site called Dippity. It allows you to make timelines. I've always used an American history timeline before, but this one's the one that's on there right now. It's the featured one. It's basically the internet memes timeline. So they go and they find the meme online and they paste it into a timeline. They can develop. So you can visually, if this was live, you could scroll back and forth and visually see the development of internet memes throughout history, I guess, of the internet. I love the Darth Vader one.
So Dippity already exists. You can't use Dippity to create a timeline for them to teach.
Yes, you can.
Oh, you can't?
Yeah, you can. You create an account. It's a social media site. You go and you create an account and add your own media or add media you find online, that kind of thing.
I think it's on the list of sites that we.
Oh, okay.
I think it is because I
So
probably
it's
put it in last year. Yeah.
Good.
Yeah, that's it. There's our contact information for where I work, and we can help you. I'll do the shameless plug and then give you over to Joe. So, any last questions? 28 seconds worth of questions. That's all I got.